On May 6, 2025, a preliminary hearing was held before Judge Michael McHenny at the Woodhaven District Court in Woodhaven, Michigan. The prosecution was led by attorney Muhammad, while the defendant, Sergio Bello, was represented by defense attorney Lillian Dio. To understand this properly, it's important to know how this type of hearing works within Michigan's legal system. A preliminary examination, also known as a probable cause hearing, takes place when someone is charged with a felony. During this hearing, the judge listens to and reviews the prosecution's testimonies and evidence to determine whether a crime occurred and whether the defendant likely committed it. If the judge finds that sufficient probable cause exists, the case is bound over, meaning it is transferred to the circuit court where serious felony trials are conducted. In this particular case, Mr. Bello faces charges of assaulting, resisting, or obstructing a police officer, and third-degree fleeing and eluding law enforcement. Both offenses are considered felonies under Michigan law. Therefore, during the preliminary examination, the prosecution's responsibility was to present enough credible evidence for Judge McHenny to determine that probable cause existed and that Mr. Bello's case should proceed to the Wayne County Circuit Court.
Any other preliminary matters? Mr. Mohammed?
No, not from the people.
Ms. Diallo?
None, thank you.
Thank you. Call your first witness.
People call Officer Gregory Brewster.
Okay.
Officer, please stand, the judge ordered. Raise your right hand. The bailiff or clerk then administered the oath. Do you solemnly swear or affirm, under penalty of perjury, that the testimony you're about to provide in this hearing will be the truth, the whole truth, and nothing but the truth, to the best of your knowledge? I do, the officer replied. All right, the judge said, acknowledging the response. You may be seated and will proceed with your testimony.
It's Gregory?
Yes, sir.
Brewster.
Yes, sir.
Okay, Mr. Mohammed, you can proceed.
Thank you. Good afternoon, Officer Brewster. Can you please restate your name to the record?
Lieutenant Brewster, Trenton Police Department.
Okay, Lieutenant Brewster, are you currently employed?
Yes.
Who is your employer?
Trenton Police Department.
And in what capacity are you employed there?
I'm a patrol lieutenant for the police department.
Okay, and were you employed in that capacity as a patrol lieutenant on January 26, 2023?
No, I was a patrol sergeant.
Okay, and on that day, did you work?
Yes.
On that day of January 26, 2023, did your duties as a police officer take you at or near the location of 1875 West Road?
Yes.
Is that located in the city of Trenton, county of Wayne?
Yes.
What took you to that location?
I was there for an unwanted subject.
Okay, and what is at that location?
It's at a gas station.
Okay, and upon making that location, what did you do, if anything?
I made contact with the clerk who called.
Okay, and what did you learn?
Oh, I'm going to object this to hearsay.
Any response?
Judge, I didn't ask about any specific statement. I'm just asking the officer what you learned since his investigation.
At least it's overbroad. Sustained, rephrase. Is this the gas station on the corner of 4th and West?
Yes, sir. King's Mobile.
Thank you.
Okay, so sir, you indicated you had contact with the clerk?
Correct.
Okay, why did you have contact with the clerk?
That was the call.
Okay, and after having contact with that clerk, did it have any effect on you? Did it cause you to make your next decision?
Yes.
Okay, Your Honor, at this time, I think the statements by the clerk would come in under effect on the listener. The officer indicated.
We'll ask her next question. She can object if she wants.
Okay. Officer, what did you learn from the clerk that caused you to further your investigation?
Wait 1 second.
So, Judge, I am going to object to hearsay. So I think the way we might do this is based on what you learned from the clerk. Did you do something as opposed to her words coming out?
Assisting.
Okay, officer, based off of what you learned from the clerk, did you do something based off of those statements?
Yes.
Okay, what were the statements that that had an effect on you and caused you to change your steps?
She told me.
Wait, no, that's hearsay. I object.
Sustained.
Thank you.
I'll just move.
What did you do next, sir? After speaking with the clerk, what did you do next?
I made contact with the person that the clerk called,
And where was that individual located?
standing next to a vehicle near the gas pumps.
Okay,
See, I could still do this, Ms. Diallo. 31 years later, I could,
How many?
31. Believe it or not. Go ahead.
thank you.
During the hearing, Mr. Muhammad repeatedly questioned the officer about the gas station clerk's statements. However, each time, Judge McNally upheld the defense attorney's objections on the grounds of hearsay. According to Rule 801 of the Michigan Rules of Evidence, which closely aligns with the federal rules of evidence and other state-level rules, hearsay refers to an out-of-court statement presented in court to prove the truth of the matter asserted in that statement. In simpler terms, a witness is generally not allowed to testify about what someone else said if the goal is to prove that the statement itself is true. For example, if a police officer testifies that a bystander said the defendant fired the gun, that statement is typically not admissible as proof that the defendant actually fired the gun, because the original speaker is not present in court and cannot be cross-examined under oath. However, there are exceptions. Certain out-of-court statements may be allowed if they fall under a recognized exception to the hearsay rule, or if they are introduced for a legitimate purpose other than proving the truth of the statement, such as explaining why an officer took a particular action. In this case, Judge McNally ruled that the officer could not repeat what the gas station clerk allegedly said. The judge determined that those remarks constituted inadmissible hearsay and therefore could not be considered valid evidence in court.
Okay, and the individual you made contact, where was he standing exactly?
Next to the vehicle.
Okay, can you describe the vehicle?
It's a red Fusion.
Okay. And was there anybody that was sitting in that vehicle?
No.
Okay, was there anybody else besides that individual standing outside of that vehicle?
No.
Okay, now that individual that was standing right outside of that, was it a Ford Fusion?
Yeah.
Standing outside of that Ford Fusion, do you see that individual in the courtroom today?
Yes.
Can you please point to that individual and point out an article of clothing that individual's wearing?
A black suit coat.
Your Honor, please let the record reflect the witness has identified him.
Record should so reflect.
Thank you. And did you initiate contact with that individual that you just identified when you were at the scene on that day?
Yes.
How did that begin?
I don't remember my exact words, but I think I said, "Hey, what's going on?" Or
Okay.
how's it going?
What happened next?
The radio in the car was very loud, and I believed it was going to be difficult to have a conversation with the person. And I asked to turn the radio down. I said, "Can we turn the radio down?" Something to that effect.
Okay, besides that, was there any other observations that you made?
When I first made contact with him, I noticed.
And who's him, just for the record?
The defendant there.
Okay,
When I first made contact, I noticed that the person was unsteady on his feet and he had red eyes, red bloodshot eyes.
okay, and based on your training and experience as a police officer, what is that indicative of, if anything?
I believe that he was under the influence of something.
Okay, and so what happened next?
Against my better judgment, he sat in the car to, I believe, turn down the radio, but that's not what happened.
Okay, what happened next?
The person attempted to put the vehicle in drive and
Oh, okay, before we get to that, where did that individual sit?
dressed.
Okay, at that point, was the vehicle on or off?
It was on.
Okay, and after that individual sat in the driver's seat, what happened next?
the person put his foot on the accelerator and tried to put the vehicle into gear.
How do you know that?
So I saw it.
Okay, and what happened next?
I told him to stop twice,
Okay,
very loud,
okay, and why did you tell him to stop?
because I believed he was trying to leave.
Okay, and when you told him stop the first time, did he say anything in response or do anything?
No,
Okay,
he continued to try to put the car in gear.
okay, and what about the second time? What happened after that?
Same thing. He continued his actions,
Okay, and what was his actions that you were observing?
that he was trying to put the vehicle in drive.
Okay, what happened next?
The vehicle got into drive and the driver of the vehicle left.
Okay, and the driver of the vehicle, just, I wanna confirm for the record, that's the same individual you identified here in court?
Correct.
Okay, and what happened after that?
The vehicle drove east towards one of the entrances/exits to the gas station onto 4th Street.
Okay, and do you recall what the posted speed limit is on 4th Street?
On 4th Street, it's 50 miles per hour.
Okay, and based off of your observations, what did you do?
My vehicle was parked on the opposite side of the gas station. So I ran back to my vehicle, got my vehicle.
So just so I know, you were on the west side of the building? Is that where you were?
My vehicle was parked on the west side of the building. I walked into the gas station and then I walked out.
So now when you were confronting him, you were on the east side of the building?
Correct.
He pulled out and started traveling southbound on 4th?
No, northbound.
Northbound, okay.
And you indicated that the posted speed limit in that vicinity is 50 miles per hour?
On 4th Street, M85, correct.
Okay, and what did you do next?
I ran back to my patrol vehicle to get in and attempt to pursue.
Did you attempt to pursue him?
I never turned my lights on. I thought I saw the vehicle turning north onto now the northbound lanes. So my assumption was that the vehicle went.
You may object to speculation.
Okay, so you can testify, and I'll keep on record that portion up to my assumption was.
Okay.
All the rest is strict, that language is stricken. You can ask your next question.
I would agree that it is. And so what did you do after that?
I saw a vehicle turning from eastbound West Road to northbound 4th Street. I believed that vehicle was the vehicle that I was after because I saw taillights of that vehicle turning. So I drove south on the 4th Street to the turnaround to try to catch back up to it, to go back northbound and catch up to that vehicle.
Okay,
There's a no left turn signal there, is there not?
Yes.
So in order to turn from eastbound West Road on the northbound 4th, he had to disregard that signal, correct?
Yes, sir.
And you turned back southbound on 4th, did the Michigan turn, and now we're heading back northbound on 4th.
Yes, sir.
okay, and were you able to locate that individual, the defendant?
No.
Okay, and so did you learn anything else pursuant to your investigation?
I returned to the gas station and spoke to the clerk.
Okay, and what did you learn?
Oh, no, I would object to hearsay, anything she said. Thank you.
I learned that
Wait a minute,
What-
slow
hang
down,
on.
slow down.
Judge, I'm not asking for a specific statement, so there's no specific out-of-court statement. I'm just asking also what you learned pursuant to his investigation.
Any response to that?
So I think you can ask, and this is just me, I don't know, it's up to the judge. Based on your investigation, what did you do next without saying the specific words? Because we know hearsay is a statement offered by the declarant, other than while testifying at the trial or hearing, offered to prove the truth of the matter asserted.
Wow.
I've been 30 years too, Judge.
Go ahead,
I would
Mr.
agree.
Muhammad.
Officer, based on your investigation, what else did you discover based on your interaction with the clerk?
I learned that I went the wrong way and was pursuing the wrong vehicle.
Okay, and did you learn the correct way that the individual fled from the scene?
I learned that the vehicle went, I saw the vehicle turn north onto southbound 4th Street, but I learned that it did not go that way. It went west on West Road.
Wouldn't that be hearsay, Judge? What you learned? Because you had to learn it through hearsay. So I would ask that that be stricken objection hearsay. And speculation.
And Judge, I would disagree. I think there's no specific out-of-court statement that's being offered. I think the officer is just testifying to what he learned pursuant to his investigation. There isn't a specific out-of-court.
You have to bring it within an exception, or he'll argue it isn't hearsay.
Well, I guess my first argument is that it's not even hearsay because there's no statement. But if the court is implying that it is, then
Wait a minute, how's there no statement? If he learned after talking to her, no matter how you phrase it, he learned based on her statement, right?
he learned pursuant to his investigation that the individual had turned a different way. But hearsay is when we're introducing a specific statement. There isn't a specific statement that the officer is testifying to. He's not saying John Doe stated X, Y, and Z. He's just saying, I had a conversation.
It's still based on hearsay, no matter how you cut it. Otherwise, you could get around the hearsay rule every single time. It'd be like anybody asking anybody, what did you learn after speaking with them? That statement is still hearsay. I'm going to find that it goes to the declarant's state of mind, and I'm going to allow it.
Understood. Thank you.
Ask your next question.
Thank you.
Judge McGinn ultimately ruled that the gas station clerk's remarks did fall under the category of hearsay, but still allowed the officer's testimony under a recognized exception, the declarant's state of mind. As previously explained, hearsay refers to an out-of-court statement presented in court to prove the truth of what was said. In this exchange, Mr. Muhammad argued that the officer's comments about the clerk's conversation did not constitute hearsay because the officer didn't quote the clerk's exact words. However, the rule clarifies that verbatim repetition isn't required. Even if a witness paraphrases or summarizes what another person said, it can still be considered hearsay if it's being used to prove the accuracy or truth of the original statement. There are, however, certain exceptions that allow hearsay statements to be admitted as evidence. Under Rule 803 of the Michigan Rules of Evidence, a well-established exception permits statements that reflect the speaker's then existing mental, emotional, or physical condition. This means that if someone expresses their current feelings, intentions, or state of mind, that statement may sometimes be introduced to demonstrate that their mental or emotional condition was indeed as described at that time. In this case, Judge McGinn concluded that the clerk's out-of-court remarks described his own immediate thoughts or emotional state rather than asserting factual claims about someone else's actions. Because the statements were tied to the clerk's present mindset, they qualified under the state of mind exception. As a result, the judge admitted the officer's testimony into the record, deeming it admissible under this narrow but well-recognized evidentiary exception.
And did you learn based off of your discussion with the clerk the street that the defendant had fled from? That the defendant had turned onto?
West Road.
Okay, and do you know what the posted speed limit is at that location on West Road?
35 miles per hour.
Okay, no further questions.
Did you ever apprehend the defendant?
Me? No.
Okay. Ask your next, any cross? Do you have cross?
Just 1 second, Judge, I'm thinking, right? real
Okay,
quick.
take your time.
Just one question.
Yes, ma'am.
You weren't sure at first who the person was because it could have been a host of people. Is that fair to say? Like, you said you thought it was the brother.
No.
Well, wait a minute. The brother's name is one of the Blues, right?
Are you,
So you didn't know who the person was. Is it fair to say it first?
I did not know that.
I don't have any other questions.
Mr. Muhammad,
No further questions.
you can step down, call your next witness.
No further witnesses from the people.
You have no further witnesses. What are you gonna do?
Judge, I'm gonna motion for a bind over, I believe. Testimony reflects a question of fact, the trier fact, and I'm gonna reserve any remark.
Any argument, Ms.
I
Diallo?
object to any bind over on these particular facts that were presented. We don't have identification. There are a whole host of things that are wrong with this matter. For probable cause, we object.
Mr. Muhammad?
Judge, in regards to identification, the officer indicated that he made contact with the defendant at the scene, and he identified him as being that person here in court today. I think in-court identification is sufficient for probable cause. We're not here determining guilt, just whether or not there's probable cause of a crime, and I believe we established that on this record.
Anything else, Ms. Diallo?
No, Judge, you've heard the facts of this particular case. I think I don't know what happened out there, even by probable cause standards, but I believe the officer testifies the person that he thought was doing one thing wasn't doing what he thought. It was the wrong car. It's a mess. It's Judge. We don't think there's probable cause at this stage, so for that, we would ask the court not to bind over.
And Judge, may I have a just brief response? In regards to the R&O, the officer indicated that he was in full uniform and that he made contact with the defendant. He gave him 2 lawful commands, at least from what I recall, to stop, and the defendant did not stop. He then fled from that location. The officer he gave the defendant voice. The defendant was a driver of the vehicle, and he gave him voice signals to stop. The officer was in full uniform, and we also learned that the defendant did not stop and willfully fled from this scene. Shortly after, we learned that the posted speed limit on West Road was 35 miles per hour. I know in regards to learning of the 35 miles per hour, it wasn't the officer who had personal knowledge, at least did not appear that way to me. So in the event the court is not inclined to bind it over on the fleeing 3rd degree, I would request it be bound over in 4th degree. Nonetheless, I do believe, because today's probable cause testimony is sufficient as charged, but if the court is inclined not to bind over on the 3rd degree, I would request that it would be done in the 4th degree. Thank you.
Any response to that, Ms. Diallo?
Mr. Muhammad requested that if Judge McN decided not to bind the 3rd-degree fleeing and eluding charge over to the circuit court, then at the very least, the case should be bound over as a lesser 4th-degree offense. According to Section 257.602A of the Michigan Compiled Laws, it is a crime for a motor vehicle driver to willfully disregard a police officer's signal to stop, whether by accelerating, turning off the vehicle's lights, or otherwise attempting to evade law enforcement. In Michigan, fleeing and eluding is generally classified as a 4th-degree felony. However, if the prosecution can prove that part of the pursuit occurred in an area where the posted speed limit was 35 miles per hour or less, the charge can be elevated to 3rd degree, which carries a harsher penalty, up to 5 years of imprisonment. This distinction depends largely on the circumstances of the pursuit and, specifically, the speed zone where it occurred. Therefore, Mr. Muhammad argued that if Judge McN concluded there was insufficient credible evidence to prove that Mr. Bello was fleeing within a 35 miles per hour or lower speed zone, the proper course of action would be to bind the case over as 4th-degree fleeing and eluding. This, he contended, would both acknowledge the seriousness of the alleged conduct and maintain consistency with the level of evidence presented during the preliminary hearing.
I'm talking about with his request to 4th degree.
So, hold on, I'm pulling it up right now, Judge, so I know the 3rd degree should have fallen. with this particular set of circumstances. I'm pulling up fourth degree right now, but we still, how do we get past the identification therein? You said you went after one car, and then it actually was a different car. So I don't know, Judge, but the fourth degree I'm trying to pull up right now.
So essentially, it's just about the 39.
Yeah, but not only that, Judge, but he didn't even have his lights and sirens on. Remember, he said he didn't. I heard that. Hold on. He said he didn't have his lights and sirens on for number one. But I'm gonna pull it up right now, Judge, to see what fourth degree looks like.
And Judge, just
I've heard enough. I'm troubled here because what you have is an officer that was called, seemingly doing the right things, going over talking to a clerk, deciding he needs to make contact with the subject, goes up, makes contact with the subject, tells the defendant, in this case, Mr. Belo, that he shouldn't leave, that he didn't want him to go anywhere. But the very essence of fleeing and eluding is that he's fleeing and eluding the statement. I'm troubled because in this case, you're right, Ms. Diallo, he did not have his lights on. He was not pursuing the vehicle he was not pursuing the suspect vehicle. He didn't know where the suspect vehicle went. For all we know, the suspect vehicle, I shouldn't interject in the record, but there's an area there where you can easily get to a 25-mile-an-hour speed zone. The officer was never in his vehicle chasing him. He thought he went elsewhere. The clerk tells him something to do that as to the fact that the defendant traveled on West Road. We don't know if he traveled on West. The officer thought he traveled on Fort. He observed the vehicle that was traveling west or eastbound on West that turned left against a no left turn signal onto northbound Fort. So we honestly don't know where he went, and the officer was not pursuing him in a vehicle. I'm not even going to bind over on flee and elude 4. I'm going to dismiss. I'm going to dismiss flee and elude third. However, I do believe in the face of the questions or the answers that were, hang on.
Sorry.
I'm not going to change my mind.
I understand.
I do believe that there's sufficient evidence, though, to establish that the defendant committed the offense of assault, resist, and obstruct an officer. How successful you'll be in a trial, I don't know, but I'm going to bind the defendant over specifically only on count 2. Count 1 is dismissed. This is interesting. I can't say I've had this one come up, but I do think that there just isn't sufficient evidence to establish he was fleeing and eluding at that time. So I'm gonna dismiss that count. Let me just make a note here, please.
Judge McNahan ultimately decided to dismiss the fleeing and eluding charge entirely, reasoning that the officer never actually attempted to stop or pull over Mr. Bello when he left the gas station. Without evidence of an attempted traffic stop, the legal foundation for a fleeing charge could not be established. However, the judge ruled that there was sufficient evidence to bind Mr. Bello over to the circuit court on a separate charge: assaulting, resisting, or obstructing a police officer under Section 750(81)(d) of the Michigan compiled laws. This statute clearly defines obstructing as knowingly failing to comply with the lawful command or order given by a police officer. Judge McNahan likely found that there was probable cause to believe Mr. Bello willfully ignored such an order when he drove away from the gas station, even if no direct pursuit occurred. As of now, the obstruction charge remains active, and the case is scheduled for a jury trial on September 8, 2025. We'll continue to follow the developments of this case closely. If you'd like us to cover more courtroom moments or analyze other legal cases, let us know in the comments below. Thank you for watching, and don't forget to subscribe, like, and share to help us build a more informed and legally aware community.